everyone, and welcome to our Civil Rights Coalition panel discussion. My name is Terrance Evans. I'm a partner at Duane Morris, and we thank Duane Morris for hosting this event this evening. We also thank our amazing marketing manager, Carla Ramos, for all of the incredible work she's done in putting this together. I also want to acknowledge a few other organizations I have the honor of representing. I am the president of the Charles Houston Bar Association. I am also the director of Region 9 of the National Bar Association. I'm a member and founder of the California Lawyers Association Racial Justice Committee, and just extremely happy to be here. We have some incredible panelists that have joined us for this discussion, and I'm definitely going to acknowledge them. But I also want to thank several of the bar associations that have been instrumental in helping us have this discussion. And it's a long list of names, but I think it's important to recognize folks. So we want to thank the Asian Pacific American Bar Association of Silicon Valley, the Asian Pacific American Bar Association of Sacramento, Bay Area Lawyers for Individual Freedom, the Black Women Lawyers of Los Angeles Incorporated, the Black Women Lawyers of Northern California, the California Asian Pacific American Bar Association, the California Association of Black Lawyers, the California La Raza Lawyers Association, California Change Lawyers, the Charles Houston Bar Association, the Cruz Reynoso Bar Association, the Earl B. Gilliam Bar Association, East Bay La Raza Lawyers Association, Equal Justice Society, Equal Rights Advocates, Hmong Innovating Politics, the Iranian American Bar Association, Northern California Chapter, the John M. Langston Bar Association of Los Angeles Incorporated, the Latino Community Foundation, the Muslim Bar Association of Southern California, Region 9 of the National Bar Association, the Santa Clara County Black Lawyers Association, the Society of American Teachers, the Rich and Wiley Manual Bar Association. We are so grateful to all of you for your support, and I know that there are other organizations that we will also recognize as we go throughout the program. I want to begin by introducing our panelists and just giving them an opportunity to tell you a little bit about themselves and their organization. I'm going to begin with Brittany Armstrong Whittington, who is an amazing lawyer and the founder of the Whittington Law Firm and Judicial Chair of Charles Houston Bar Association. Brittany, can you tell us a little bit more about yourself and your organization, Charles Houston?
Sure, thank you so much. So hello, everyone. I am so glad to be here. As Terrance has said, I am the founder of Whittington Law Firm, where I practice employment discrimination and civil rights law. I also practice criminal defense. I am a former deputy district attorney. I worked out of Solano County as well as Contra Costa County. And I also, prior to that, did some employment discrimination in terms of class actions. I also sit on the board as the judicial chair of the Charles Houston Bar Association. And so one of my goals is to ensure that we continue to provide qualified and exceptional candidates for the bench, and specifically minority candidates or candidates of color. So I'm happy to be here, and I can't wait to discuss the topics that we have on the table today.
Thank you so much, Brittany. Next, we have Rafael Langer Asuna, who is a board member of the National Trans Bar Association, also a board member of Bay Area Lawyers of Individual Freedom, also co-chair at the Trans Law Institute, Lavender Law, and is a partner at the global law firm Squire Patton Boggs. Can you tell us a little bit more, Rafael, about who you are and the organizations that you represent?
Sure. I'm a litigation partner at Squire Patton Boggs, where I practice internet-based litigation and litigation involving foreign sovereigns. That's what I get paid to do. And then I also do a lot of pro bono work involving civil rights. I am here on behalf of Bailiff, which is one of the oldest LGBTQ bar associations. In fact, it's the nation's oldest LGBTQ bar association. It's local to San Francisco, the Bay Area, and it has a long history of promoting the rights of LGBTQ people, including seeking and establishing LGBTQ people in the judiciary. And it's been doing that for over 40 years. I'm also on the board of the National Trans Bar Association, which is the nation's only organization at a national level of trans lawyers. In connection with both of those, I work on amicus briefs all over the country, trying to stem the tide of anti-trans litigation and legislation that we are currently facing.
Thank you so much, Rafael. We appreciate you. Next, I have the honor of introducing Raymond Rowland. Raymond is Deputy City Attorney with the City of San Francisco City Attorney's Office, and also President of the Filipino Bar Association of Northern California, FBANC. Raymond, can you tell us a little bit more about yourself and the amazing organization that you represent?
Sure. Good evening, everyone, and thanks so much, Terrance, for having me here in this important discussion. FBANC is one of the oldest and largest Filipino bar associations in the country. The goal of the organization, which has both an organization and a foundation branch, is to uplift and empower Filipino American lawyers, students, judges, and making sure that we build a pipeline of future leaders in the community. Besides FBANC, I also serve on the Asian American Bar Association Judiciary Committee, and also serve as co-chair of the National Asian Pacific American Bar Association's LGBT network. I'm happy to be here and representing kind of my intersecting identities as a lawyer.
Thank you so much, Raymond. We're extremely grateful to have you here with us. Next, we have our good friend, Kel O'Hara. Kel is an incredible lawyer, also civil rights activist on behalf of numerous organizations. And Kel, we want to give folks a chance to hear about some of the great organizations you're involved with and some of your great work.
Sure. Hi, everyone. Kel O'Hara. My pronouns are they, them. I'm a current staff attorney and former Equal Justice Works Fellow at Equal Rights Advocates. We're a national civil rights nonprofit based here in the Bay Area, but we work nationally. And I'm also on the board of Bailiff, and I'm our current DEI chair officer. So my work at ERA really started. ERA is historically a gender justice organization focused on women and girls, looking at expanding and protecting educational and economic opportunities. And when I got involved as a fellow, I said, I think this work is really great. I'm particularly interested in education equity, but I really think we need to be talking about and thinking about the rights of queer and trans students, specifically how that shows up in the context of sexual violence under Title IX and relevant state laws. And what has happened over the past couple of years is that we started seeing the current attacks on trans kids that we're seeing become even more of an issue today. And the reason I say this is because being in the position I was in, where I was already thinking about that and was one person at my organization where I was thinking about that and talking about that, has now allowed us to pivot into that space more, for me to take more of a leadership role in that sort of work, and to the point where we're now coming up with an actual actionable impact strategy for the year ahead. So I really hope that this panel encourages y'all to think about how you're already tapped into these movements, how you can be more tapped into these movements. It is never too late to expand your practice, to think about other ways that you can get involved and to support the work that's already going on.
Thank you so much, Kel. We appreciate you. And last and certainly not least is our good friend, Christopher Panang Bayan, who is the Executive Director of California Change Lawyers and just an incredible civil rights advocate on so many levels. Chris, I want to give you a chance to tell folks a little bit more about yourself and also about the amazing organization that you lead.
Sure. Thanks so much, Terrance, for having me. California Change Lawyers used to be the California Bar Foundation. We changed our name a few years ago to more expressly make known our commitment to empowering the next generation of legal change makers, who we call change lawyers. Our mission is to build a better justice system for all Californians, and we're a community foundation focused on California's legal community. So every year we raise funds and give funds back out to the legal community through grants to nonprofit organizations and scholarships for diverse law students. We also are beginning to get involved in more direct advocacy. That's my background from when I was previously at Advancing Justice Asian Law Caucus as the executive director. And one accomplishment that I'm really proud of from a few years ago that we co-led with many organizations who are on this call was the effort to align the cut score of the California bar exam to more closely align to the national average. It was far too high and did not reflect the ability of folks to practice law in California. And we were successful in advocating the score to be changed, which would allow hundreds of more attorneys of color to become barred and practice law in California.
Thank you so
Every
much,
year.
Chris. No, thank you so much, Chris, and for all of the great work that you do and that California Change Lawyers does. Before we get into the questions, I'll just provide a brief overview of what we will be discussing today and how our coalition came to be. Essentially, a group of us from a variety of organizations across California had conversations about concerns that we had about civil rights issues, constitutional issues, and our democracy, and in trying to figure out ways that we could work together to protect those things that we feel are important. And today we're going to be covering a number of topics that have been of very popular discussion in the American media, but also in our respective communities, and explore ways that we can work together to provide some security for these civil rights and democracy issues. Some of the issues that we're going to be talking about are the affirmative action cases that are pending before the United States Supreme Court involving Harvard and the University of North Carolina. And we're going to hear a little bit more about Chris and the incredible work that he has done and led, joined by numerous civil rights organizations and bar associations throughout the state in trying to protect and preserve affirmative action. We're also going to be talking about the United States Supreme Court's decision in Dobbs versus Jackson Women's Health Organization and what the implications of that decision are, not only for the overturning of Roe versus Wade, but the privacy implications for other important constitutional rights. We'll also get into issues and discussion about critical race theory laws and what the implications and consequences are of these laws and what it means for education and so many other important areas of American life. We'll continue with a discussion about Moore versus Harper. It's a North Carolina case that is pending before the United States Supreme Court that brings before the court the issue of the independent state legislature theory and what that potentially means for our democracy. And we will wrap things up with a discussion about a number of issues that have recently happened in Florida, ranging from the Don't Say Gay law to redistricting issues to other issues that impact diversity, equity, and inclusion. And then finally, we will provide some ideas and thoughts about what we can do to preserve these important rights. And I want to encourage folks who are watching to submit any questions that you may have as we go through the program. Feel free to share those questions in the chat or the Q&A, and we'll do our best to address these issues as we go through the discussion. So beginning with the Harvard and North Carolina, University of North Carolina affirmative action cases, I'm sure many folks have heard about these cases that are pending before the court. and essentially trying to eliminate the consideration of race in the admissions process for both private and public universities. We're really fortunate to have with us Chris and California Change Lawyers, who really spearheaded an effort amongst a number of California organizations, and I'm grateful that I had a part in that to try to preserve affirmative action, but also to tell it from the California perspective. And following Prop 209, what we have seen and why this may not be the best option, which is eliminating affirmative action, and why it may be prudent for the court to listen. So I want to give Chris an opportunity to talk about what inspired him and California Change Lawyers to get involved in these cases, and what his thoughts are about what is at stake here as it relates to affirmative action.
Thanks so much, Terrance. And I just want to publicly thank you personally for all the work that you did, because you were responsible for getting almost half of the 25 amici that we got to sign onto the brief to the court. So we wouldn't have nearly had the show force from California were it not for your efforts. So thank you so much.
Thank you.
The reason why Change Lawyers and our kind of co-leaders on this were the Equal Justice Society as well, was that in the briefing that was due earlier this year to the court, Students for Fair Admission argued that California is an example of why we don't need affirmative action in higher education. And hearing that was just appalling and made me think, okay, well, I got to do something about this. And so I called up my friends at Equal Justice Society and said, we can't let the California experience go unresponded to, because otherwise the court would not know what is happening since Prop 209 passed in 1996. And the truth of the matter is that when Prop 209 passed in 1996, it had a devastating impact, particularly on Black and Latinx students in higher education in California. So immediately after Prop 209 was passed, the average annual enrollment rate for Black students at all four-year public universities in California declined by 15%. The average annual enrollment rate for Latinx students declined by 10.3%. And the impact was even worse on the UC campuses. There, the average annual enrollment rate for Black students declined by 21%, and the average annual enrollment for Latinx students declined by 12.7%. So the court is erased, the court has not erased. The Students for Fair Admission hopes to erase that harm of an entire generation of California students who are seeking greater opportunity through higher education in California. And we noted in the brief that the effects were actually felt further downstream than just higher education. In law and in medicine and in many other fields, diversity still continues to suffer. And actually just this week, the California Bar released a demographic study of California attorneys and found that only 34% of California attorneys are Black, Indigenous people of color, compared to being 61% of the state. And at Change Lawyers, we provide scholarships to diverse California law students to help defray the cost of legal education, but it's really a one-by-one approach. And so our hopes through the brief were to have a greater impact in telling the story of what the demise of affirmative action has had in California. I want to say that, the court should uphold 40 years of precedent dating back to the Bakke case in 1978, and that was upheld in the Grutter decision in 2003. In the Bakke decision, the court said that race is permissible, a permissible factor to be considered in higher education admissions. And the Grutter case affirmed that, specifically stating that the court had a compelling interest in promoting diversity. However, the conservative legal movement has been on a mission to eliminate race consciousness in constitutional law. And that's what's important to recognize this case. It has to be taken in the larger context of an attack on the rights of Black, Indigenous people of color in many aspects of American life, from education to voting. And I just want to mention voting because of the dismantling of Section 5 of the Voting Rights Act in 2013 in the decision Shelby County versus Holder is notable because the lawyer in that case, Edward Bloom, is the same lawyer in this affirmative action case. So this is, not adding up in a good way, because even with a different court, race consciousness was attacked in the voting rights context, and it seems like it's going to be a big uphill climb for us to preserve affirmative action in education with this court. So, affirmative action is one of the centerpieces of the civil rights era to create more opportunity. And the fact that we're seeing this program end in the education context means that we will be reverting back to an earlier period of American history where separate and unequal was the rule. So this is the wrong direction if the court rules as is expected, and will be a serious setback to the movement for education equity.
And Chris, thank you for that. And can you also just briefly talk about the effort to divide people of color? So specifically to divide the Asian community from the Black and Brown community, and just your thoughts on that.
Yeah, so I mean, this is very unfortunate, but Edward Bloom was able to find some Asian American plaintiffs in the case to allege that Harvard had unlawfully discriminated against Asian American applicants, saying that Harvard actively held a bias against Asian American applicants. And I think this was because of the lack of civil rights education in the American education system. I think some of the Asian Americans who, ended up being plaintiffs in this case, really didn't understand the history of affirmative action, didn't really understand kind of the broader context of racial equality that's happening in the country, and that Asian Americans and Pacific Islanders are also suffering under an unfair education system. But, what's interesting is that many Asian Americans do not oppose affirmative action in California, in particular in employment and in contracting, but it appears that in the education context, it is that way. But I will say that there was recent national polling of Asian Americans nationally, not just in California, that showed that 73% of Asian Americans support affirmative action. So I think it's slightly overstating the idea that Asian Americans are opposed to affirmative action. It's really just this small subset of disgruntled, applicants who are being, I would say, taken advantage of in the system, and to advance a larger agenda related to eliminating race consciousness in the law.
Thank you, Chris. Appreciate that. And Brittany, I want to give you a chance just to comment on your thoughts about why it's important to preserve educational opportunities for people of color as it relates to affirmative action.
Thank you. So, I think that Chris has said a lot, and to just echo the things that he said, it's very important because we know that education is essentially the vehicle to other opportunities. So it's the vehicle to different jobs. It's the vehicle to different careers. It's the vehicle to different education as it relates to post-education. And so if we don't have those levels of diversity or admittance in lower levels of education, let's say, in college, then we are going to struggle with other areas of diversity because the world is going to be stagnant in terms of what our college admissions looks like. That being said, while I agree that, affirmative action is necessary, I do think that what we are seeing now is that there is a change in terminology. And so I would just push us in terms of what are we truly asking for. The new kind of affirmative action is now called diversity, equity, and inclusion. And so a lot of organizations, a lot of schools, and a lot of jobs, they do try to achieve what affirmative action has achieved in the past, but they do it through the guise of DEI. And so I think that we do have different avenues to still get to this place. But overall, I do think it's important for us to make sure that we're not dismantling things that were hard fought for and that were effective and impactful. And I think Chris's numbers show that it was impactful and that we do need to have these systems in place so that we can ensure that the world is more diverse.
I appreciate that, Brittany. Did anyone else want to comment on the affirmative action question? I think it's also important, and thank you, Brittany, to remind folks why we even have these affirmative action programs. And it's because of the systemic racism that people of color experience for hundreds of years, including in states like California. Until the passage of the Civil Rights Act of 1964, there was no guarantee that anyone of color had the opportunity to attend a public school or even a private school or an institution of higher learning. People wonder, why do we have historically Black universities? It's because people of color, Black people in particular, were excluded from predominantly white schools. And so the only option to educate Black people and other people of color is to create separate institutions. You can think back to the whole concept of separate but equal, often was not equal, so that these individuals could have the opportunity to learn and study. During slavery and even after slavery, there were laws on the books that made it illegal to even teach slaves how to read, let alone to send them to institutions of higher learning. And as we moved past Reconstruction and we moved into the Jim Crow era, there was active discrimination, not just against Black people, but against all people of color as it related to everything from education to public accommodations to jobs to even being admitted to practice law, which is why we have so many diverse bar associations. Because people of color did not have the opportunity to be part of the American Bar Association for the first 100 years of its existence. So the only option, if you wanted to be in a bar association, was to create your own bar association. So it's the history of discrimination, it's the history of exclusion, systemic racism that made it necessary to create these opportunities for people of color. And if we think about it, it really hasn't been that long, right? We had the Civil Rights Act of 1964. That's what, about 60 plus years ago. And here we are already reversing the opportunities that were created just a little bit over a generation or two ago. So I think it's an important discussion, and it's important for us to have this conversation and think about what the implications are. As Chris said, we're under no illusion that the odds are not stacked against affirmative action. There is a 6-3 conservative majority. So we know that more than likely it's going to be a huge challenge to keep this going. But we appreciate the efforts of Chris's organization and all the other organizations that signed on to the brief. We're now going to move into a discussion about Dobbs versus Jackson. This, of course, has gotten a tremendous amount of media attention. And it is the most recent decision by the United States Supreme Court that ended Roe versus Wade, which essentially gave women the ability to make their own decisions and control their own bodies. But the implications of the Dobbs decision go well beyond just abortion, because it, like many other important rights, is based on the right of privacy. And there are concerns that with the Dobbs decision, other rights are now potentially threatened, including the right to contraception, the right to marry the person that you love, regardless of their gender or their sex, and the right to engage in intimate relations with someone that you love who is also a consenting adult. So lots of those issues, and I just want to give folks a chance to comment on some of those concerns. And Rafael, I'll start with you. how does Dobbs potentially threaten other rights? And I listed a few. And if you could just kind of share some of your thoughts on that issue.
Before I get there, and as part of my answer, I want to go back to this notion of dividing communities. A lot of my experience recently is in civil rights litigation on behalf of the trans community. And one of the things that we've seen in conjunction with that is a series of media attacks that go along with it, where there will be letters to the editors, things like that, that are put out to sort of sow the idea that there should be this sort of reconsideration. Well, for most people now that there's more trans visibility, it's consideration for them. But in actuality, it's reconsideration of things that have been in place for decades, if not a century in some instances or more. But these ideas that are being promoted are being put out there actually by many of the same organizations that have been working to roll back abortion rights. So the Alliance Defending Freedom, for instance, they've been publishing letters to the editor about trans rights. They've been also working to roll back abortion rights. And what we're seeing here is that they're trying to divide off the trans part of the LGBTQ community because they are seeing that they're getting a little bit better polling in presenting different issues because of the popularity of things like gay marriage, for instance, that is, more readily accepted within society. And so they're trying to do this. I don't think it's very successful within the LGBTQ community, thankfully, although we're seeing experiments along those lines overseas in England. But all of these forces are working together, and they were targeting abortion rights specifically so that they could get what you will find in Justice Thomas's concurrence, where the attack on the substantive due process rights that underlied the right to abortion in Roe and Casey is actually just the first step in attacking those rights that you just enumerated through attempting to overturn Obergefell, Griswold, and other such cases. I see Kel has unmuted themselves, and I definitely want to cede the floor to them so that they can also add their thoughts on these topics.
Yeah, I mean, I just wanted to quickly say that the ways that division of trans folks from the rest of the LGBTQ community has not necessarily worked super well in that community. Where it has worked very well, and where I'm seeing it come up is in gender justice spaces. And so as someone who's working in gender justice, particularly on Title IX, which is an area that, my organization and Title IX were founded in the 70s. And so a lot of the people that were on the same side as us until now, we have now hit like this really noticeable and difficult splitting point along are trans people protected by gender justice laws? Is sexual orientation protected under Title IX and these other gender-based civil rights laws? And that has been really effective. My organization got a grant to be working on work around trans inclusion in student athletics. And actually the folks in that coalition came back and said, we need to abandon this topic completely because it is becoming so divisive that trans advocates are worried that we're going to lose out on things like gender affirming healthcare and these other really big things because athletics becomes such a sticking point. And a lot of that was pushback from cisgender women and girls who were like, well, this isn't fair to me. This idea of like biological men, which is really offensive and awful, right? And so the ways that, and that has ultimately made us less powerful because, as Rafael was just saying, a lot of these same forces are at work. And if we were all on the same page about what and who is behind these attacks on these same civil rights, we would be so much more powerful. And we're really undermining not just civil rights for everyone, right, but our ability to push back on these kinds of attacks when we play into these divisions. And I'll pass it back to you with that, but I wanted to make sure that that was highlighted as we got into the abortion discussion.
Rafael.
I just note that, a lot of the civil rights movement resulted from both intentional and also fortuitous coalitions of individuals who have minoritized identities coming together, whether it be the disability rights movement, queer rights movement, the rest of the civil rights movement. These things all happened, and they happened successfully because people work together. And it's really critical not to fall into these things, to allowing these strategies of division to be successful.
Appreciate that. And Raymond, I see that you've taken your phone off mute. I want to give you a chance to respond to this. And then I also want to address a question we received in the chat, but go ahead.
Sure, just my comment about the affirmative action issue. I know we're backtracking here. But, I think to me, as what Chris said earlier, this is really an agenda, right, to perpetuate systems of oppression. And this new wave is just a renewed effort by the right to gatekeep systems of privilege and power that exist in the community. And, make no mistake that this new strategy, one that places an Asian American at the forefront of the litigation versus a white person in the Bakke case, really capitalizes on this energy in this country to divide communities of color, and to keep kind of the white voice on the side and pit people of color against each other. But we know, for instance, we know for a fact that Asian Americans are is a population that comprises of many pan-Asian ethnic identities, majority of which are marginalized, underrepresented, and low income, right? So not only a fraction of the Asian population in the States can even afford or even think about going to institutions like Harvard, right? So as Chris said, like 73% of Asian Americans who in the country still feel like affirmative action policies would benefit them. And it's because they would, right? Because there's still immense inequality in those communities and in other communities of color. So this is really a frank reminder that racial equity issues are still ongoing, right? Like more than ever, and that it impacts all sectors, right? Not just education, but employment and health and everything else, right? So it really is imperative that we think critically about these issues and the way that we can all collaborate to respond, like just like what Chris is doing with his organization and amicus brief that you filed.
Oh, I was just going to follow up on that briefly, and then Rafael, I'll pass it to you. There was a question that we got in the chat about division and tension between the Black community and the Asian community. And Raymond, I just wanted to give you an opportunity to talk about why it's important to build bridges and why we're, stronger together as opposed to allowing the divisions to remain. And I think it's important to acknowledge that there are divisions between all different communities, regardless of color or race or ethnicity, but it's about how do we build bridges between these communities so that we're stronger together. And if you could just talk a little bit about why, at least in your view, you think it's important to build these bridges and bring communities together.
Sure. I mean, this notion of collective liberation is what comes up to mind, right? That all people, all communities of color in this country are impacted by the same systems of oppression and white supremacy culture that deprives all of us from equity and opportunities and advancement, right? So when there are efforts that intentionally seek to pit communities of color against each other in this kind of oppression Olympics type of discussion, it only serves to pull us all back, right? Like all communities of color back, right? And we saw this in kind of the anti-Asian hate crimes incidents that happened last year, where you know, folks were rallying in response to the George Floyd event. And then there was, you know, and then the energy shifted to the anti-Asian hate crimes, and, you know, the communities were placed against each other in terms of like, well, you know, you marched with me, how come I'm, you know, how come I marched for you, how come you're not marching for me, right? But I think people need to understand that we are all, again, like suffering under the same oppressive system, and the more we encourage that rhetoric, the more we actually detract from all of our collective abilities to move forward, right? So it's really important not to look at what divides us, but what unites us, right? And that's the only way, like cross communities and cross ethnic identities and cross whatever it is that you, however it is that you identify, that we can start to think about solutions to the bigger issues that we are all facing, both structurally, systemically, institutionally. But we won't be able to do that unless we get together and think collectively.
Very well said. And Rafael, I want to pass the microphone back to you. And if you could also just comment on this idea, you have folks who are in blue states, you know, states that are controlled mostly by Democrats, who feel like, why should we worry about this, right? We're safe. Who cares about the rest of the country? And if you could also comment on why that's not the best way to think about these issues, why we should be thoughtful about what happens in red states and blue states in any state.
Yeah, I mean, a couple of thoughts on this. So, I mean, with respect to the idea of peeling off the trans community, and I'll get to your question in just a second, we can see in Florida that after Texas and Florida kicked around this idea of targeting the trans community, they moved on and incorporated in what was really anti-trans legislation in this Don't Say Gay bill, more than just gender targeted discriminatory laws. It's now actually targeting sexual orientation. So many of these laws are test cases. They're being tested in Florida, they're being tested in Texas. Make no mistake that part of the reason why Ron DeSantis is pushing these agendas is to test how popular they will be in pursuing presidential ambitions, no question about it. But more importantly, peeling back one community's rights is actually usually a first step, as we can see with the trans community, in peeling back the rest of the community's rights. And so you're seeing that not only using the so-called red states as test kitchen for these sorts of things, not only the political movements, but also the rhetoric. And then you're also seeing that used as a method to leap onto the national stage. And as I'll turn it back in just a second, because I think one of the things that's critical about our conversation is the Moore v. Harper conversation. I want to put that back to you, but the notion that somehow these things are independent is really kind of false. To what Raymond was saying, if we look at the Dobbs decision and we look at the effects it's going to have, the twofold. One, taking away abortion rights, the national right to an abortion is going to disproportionately impact those people who cannot go somewhere else to get an abortion, right? That's everyone who might have some sort of other reason why that'll be harder to do, and specifically communities of color and whatnot. Now, and then of course, there's the very clear, not even telegraphing, just direct statement by Justice Thomas saying that, based on the legal reasoning in the Dobbs decision, that he'd like to see the court go after Griswold, which is the right to contraception, Lawrence, which is the right to anyone having very slim margin of specific sexual acts in the bedroom, not just gay people, and also Obergefell, the right to gay marriage. So it's this combination that we're seeing of using not only legal maneuvers, but also propaganda in sort of test kitchens, and also the fact that these, the strategy seems to be one of essentially dominoes, trying to pick the what they perceive to be the weakest target, pushing on that, and then once that gets rolling, moving on to other communities. And I think the Moore v. Harper decision is going to be absolutely critical to seeing whether or not these test runs essentially can be brought to a national level in a way that will make it very challenging for those of us, even in states like California, to contest.
Can I add to that, Terrance, before I move on?
Oh, sure.
I just want to highlight this while we're on the subject of Dobbs, which is like, what is that issue in Dobbs? First of all, I want to highlight something that I hadn't even thought about until it was pointed out to me at a conference the other day, which is Dobbs marks the first time that a constitutional protection has been taken away. And that is huge. And we don't have precedent for it, so we don't know what happens now. But what we have seen with Dobbs is that there was an instantaneous catastrophic effect because there are so many laws on the books from before the time that Roe was implemented that were never taken away. And so when you attack a civil right in that sort of way, and those laws are still on the books. So we think about more red-leaning states, for example, that maybe intentionally left those laws on the books, had trigger laws just waiting for these things to go into effect. There's a very real threat to all sorts of civil rights if this way of approaching things is allowed to continue. And for folks who are, not as familiar with the actual reasoning in Dobbs, so what was at issue was privacy rights, specifically personal autonomy, which is where all these other things that are threatened comes from, this undermining this idea of personal autonomy. But also really what they were talking about at the highest level is this idea of fundamental liberty and a reversion to this interpretation of fundamental liberty that is, it's either exactly in the Constitution or it is, to use the language from Dobbs, deeply rooted in American culture and tradition. But what have we prioritized in American culture and tradition? Whiteness, cis heterosexuality, the patriarchy, a system of oppression that would hurt all sorts of historically marginalized people. And so, the threat in Dobbs is not just abortion. It is the fact that we've now seen the civil rights protection taken away. It is the fact that we're seeing this reversion to an idea of fundamental liberty that is so unnecessarily limiting and just completely out of touch with our current reality, intentionally, right? This is not people who just love the Constitution that much for the most part, right? Like these are strategic attacks. And so I really, I think that the dangers here that we're seeing and these connection points that we're seeing, the reason that we're having this is because we really can't emphasize enough how much this all overlaps, right? And the fact that you cannot fully understand any one of these individual cases or any one of these individual attacks without seeing that there's a larger pattern that's all coming to the front right now.
And Brittany, I want to bring you into this discussion because there's a lot of concern that the Dobbs decision and efforts by numerous states to limit the ability of women to control their own bodies and make their own decisions could disproportionately impact Black women and other women of color. And I just wanted to give you an opportunity to talk about any dangers you see in restricting the ability of women to make their own decisions. For example, there was a news story just a few weeks ago of a woman who wanted to get her tubes tied, and she was told by the doctor that she had to get her husband's permission in order to do that. There's a news story that came out this morning of a young woman who thought she was having confidential communications using Facebook Messenger about her need to terminate a pregnancy, and that information was used to prosecute her for murder, which is just, mind-blowing. What are your thoughts about this and what it means for women of color?
Yeah, thank you. I think it has great implications on women of color. It also has great implications on minority communities. When we talk about access, access is already lacking in minority communities, as small or as simple as even grocery stores. There's not Trader Joe's, there's no Sprouts, there's no access in that regard. So then when you take it to even a higher level of access in terms of healthcare, you're changing the dynamics by having these laws come into play where people of color already are limited at what resources they have at their fingertips. I think another very big issue is that, oftentimes if you already don't have access to birth control, and then you may become pregnant and you did not intend to do so, now you have a child that you don't want. And so I think that there's grave implications, again, when it comes to access. Now you have a domino effect of things. You now will have children who are in the system. You will now have children who are now looking or seeking for homes or different things. So I think that there's so many effects that this comes into, but the biggest one I also see, and I see the world going in this direction, is privilege. We've already heard about incidents where, young people who have arguably been molested because a 10-year-old should not be pregnant. So you have young people who are being molested, but then the people who they are being molested or raped by just send them thousands of dollars to transport them to another state to cover up what they were doing. And so you see privilege really playing out, as it does in a lot of areas, but you see privilege playing out a lot in this. So people who have money, people who have connections, they are still going to have the access and get the abortions, whereas this is really primarily going to affect people who are impoverished and people who already probably need the help or support, and it's going to just create more issues in that way.
Appreciate that. And before we move on to critical race theory, Chris, I just wanted to give you an opportunity to just talk about the danger that this means for other privacy rights, in particular, same-sex marriage. There was an effort in the Senate to try to get a bill, but it seems to be stalled. And what the danger would be if folks accept the invitation from Justice Thomas and try to eliminate these rights that are so very important.
Yeah, well, I think Kel kind of nailed it on the head earlier, in terms of like what we can expect to come from this court, that they've already taken away a right. In this case, a 40-year long standing right. Obergefell has been around 6 years. And so in terms of, just it would seem easier than the right to reproductive health, to remove the right to marriage equality. So I think the threat is real. I have no doubt that the conservative legal movement in some state in the country is getting together a case that they could send up to the court, because they have this precedent and they have this 20-year plus lock on the composition of the court. I think it is noteworthy that I believe the House did pass the bill to codify Obergefell, and I think you're right, it is stalled in the Senate. So, in terms of what can be done at this point, I think, a lesson is that Roe should have been codified. The US was one of the very few countries in, the democratic world that had this right via judicial decision versus legislated. And so I think if this Congress, is going to get something done before November, this would be, and guess what? The climate change bill passed in the Senate. So, maybe there'll be something there. But I think the threat is real. And I think it is, it's already been like Justice Thomas was inviting the case, essentially. So I think we really do need to steel ourselves, on all fronts to prepare against that case going up.
Thank you, Chris. So our next topic that we're going to get into is critical race theory. And I'm just going to share my screen briefly to help frame this discussion. So over the last 2 years, I've spoken at, nearly 100 different events where we've talked about race and diversity, equity, and inclusion. And I just want to help us understand what this issue is when we're talking about critical race theory and how the issue has become politicized over the past year and a half. So going back to May 13th of 2021, I was given a presentation and I started to track how states were looking at critical race theory, and we'll get into a little bit more of what we're talking about, but essentially examining issues and circumstances with a historical lens that takes into account some of the discrimination and racism that folks have experienced in the past. So back May 13, 2021, there were 14 states that had banned or were in the process of banning diversity and inclusion, training and critical race theory in instruction. And I want to make it clear that no high school, no middle school, no elementary school has ever taught critical race theory. This is a college level, graduate level discussion that has taken place in a select few schools. So this notion that we need to protect young people from this is a bit outrageous. And what it has done, many of these laws have been expanded to include just basic diversity and inclusion discussion. The very discussion we're having now, back in May of 2021, would get you fired in 14 states in the United States. So we kind of fast forward to June 14, 2021. I did several Juneteenth programs, including one for the employees of UC Berkeley. I checked in again to see how these laws were progressing. And as of June 14, 2021, there were 21 states in the United States that banned critical race theory, diversity and inclusion instruction. Many of these laws have also been expanded to include any discussion about LGBTQ issues. We'll get into that and what's happened in Florida, women's rights issues, super strenuous restrictions. In October of 2021, I had my 9th annual citywide diversity program, and a quick plug, on October 13 of this year, I'm going to have my 10th annual citywide diversity program. But a year ago, October 2021, there were 28 states that had banned discussions of diversity, equity, and inclusion, critical race theory, LGBTQ issues in public schools. It's been expanded to universities. It's been expanded to any state-run agencies, and in some cases, as we'll get into Florida, also expanded to private businesses. I did a number of Juneteenth programs this past June. You can see one of them that is up on the Charles Houston YouTube page, on my own personal YouTube page. And as of then, there were approximately 36 states that either had banned or were in the process of banning any type of diversity and inclusion training in public schools, in state agencies, in universities, colleges throughout the United States. So the discussion we're having now in 36 states would get all of us fired. I'm going to fast forward really quickly because I just want to cover just a tiny bit, a crash course of some of the issues that are being included as part of this discussion of critical race theory and preventing people from understanding some of the unfortunate aspects of our history. And I always like to use California as an example. California has a Jim Crow past, as does all the other states in the union, but California had signs like this all over the great state of California that sanction discrimination. And we'll have a lot of this information going to be in my Juneteenth program. But I just want folks to understand, for approximately 100 years in the great state of California, we had laws that barred non-whites from testifying in any case where a white person was a party. It didn't matter if it was a personal injury case. It didn't matter if it was a business dispute. It didn't matter if it was a criminal case. Non-whites could not testify against whites in any case. Barred non-whites from serving on a jury. Barred non-whites from voting. Yes, in California, non-whites barred from voting. Barred non-whites from holding elective office. Couldn't be dog catcher, couldn't be mayor, couldn't be councilman, couldn't be anything if you were not white. Barred non-whites from serving as judges. We know this happened in all 50 states, but it happened specifically here in California. Barred non-white attorneys from questioning white witnesses. So if you look like me and the witness happened to be white, the white witness didn't have to answer your questions. Now, this ended in federal courts in California before it ended in state courts, but this was the situation for many, many decades, nearly 100 years in California. Barred non-whites from public schools. We've just had our affirmative action discussion. It included not only primary and middle and high schools, but also colleges and universities, bands, a few other things, just so that folks understand. And this is information that folks who have passed these critical race theory laws in 36 states don't want young people to know. Barred non-whites from buying and renting property. Folks wonder, why do we have Black neighborhoods and Hispanic neighborhoods and Asian neighborhoods? It's not just because these groups of people loved each other and just wanted to be together. They were specifically barred from living in certain neighborhoods. Barred non-whites from being buried in certain cemeteries. The discrimination didn't just exist for living people of color, it existed for dead people of color. Barred non-whites from restaurants, hotels, theaters, pools, hospitals, beaches. This is self-explanatory, but I want to really hit on hospitals. So in California, as was the case in all 50 states, if you were not white, you couldn't go to any hospital. You're in a car accident, you're giving birth, you have a heart attack, you would only be allowed to go to a hospital that served people of color. My mother and all of her siblings were born at home because they did not live near a hospital that served people of color. There was no hospital that would admit them, period. That was the case here in California. People don't know that, and the folks who are pushing these critical race theory laws don't want anybody else to know it. Barred non-whites from admission to bar associations. We already covered the minority bars, all these other bar associations for underrepresented groups. It wasn't just for fun. It was because white bar associations, state bar associations, city bar associations, the American Bar Association would not admit non-whites. Barred non-whites from public transportation. I can't get into it now, but if you go to the YouTube video I did for Juneteenth, I talk about the very first desegregation of public transportation happened in San Francisco. And I go into detail. This was about 100 years before Rosa Parks. Barred non-whites from equal pay for equal work. Didn't matter if you had the same education, the same tenure, the same whatever, you did not get paid the same rate as somebody who happened to be white. And when the Civil Rights Act of 1964 was passed, big labor negotiated that when that was passed, there would not be any sort of catch up. So for the numerous people of color who have been working for decades on jobs, they wouldn't earn tenure at the same rate as whites, even after the Civil Rights Act. So if you've been on a job for 20 for 5 years or 10 of those years, you won't get credit for the full 20 years like somebody who was white. And we already talked about the miscegenation laws. I won't go into all the details. All of this is going to be in the Juneteenth video, but we had numerous case law that talked about the discrimination against people of color, People versus Hall in particular, where they tried to decide if Asian people would be treated like Black people or white people. Numerous Asian people witnessed a murder. And the issue was, were they going to be deemed competent? There was a specific statute on the books, Section 394 of the California Practice Act. And long story short, the California Supreme Court decided Asian people would be treated as Black people. The term Negro was a catch-all phrase. And so even though there were dozens of Asian people who witnessed this brutal murder, they were all deemed incompetent. And the white person who committed the murder was allowed to go free. So we'll save that for another time. But as we get into these critical race theory laws, they're laws that are trying to whitewash history. They don't want to call slavery slavery. They don't want to talk about segregation. They don't want to talk about anything that was negative or bad or uncomfortable and makes people feel bad. And so I just want to give folks an opportunity to comment on why they think it would be bad to allow this whitewashing of history. And Brittany, I'm going to start with you. Why do you think it would be unfortunate? And by the way, if I was a public school teacher in any of those 36 states, I'm fired. I would have just lost my job. They would have arrested me and carried me out. My career is over. If I'm a university professor in those states and I'm at a state-run school, the information I just shared with everybody on this Zoom, I'm fired. I'm out of a job. If I work for the county or the city or the state in any of those 36 states, what I just showed you would have got me fired. My career is over. Don't know I'm gonna get gas money. Don't know I'm gonna pay my mortgage payment. So, Brittany, why do you think it's important to not whitewash history? Why do we need to know about all these horrible things?
Well, I think the biggest and most profound statement that's very simple is knowledge is power. So when people know things like history, when people know things that have been done, things that people have accomplished, it allows them to be able to see what they can do too. And so when you know, okay, you have slaves, right? Who have actually created the iron, who created the pressing comb, who created, things like the stoplight. When you know that, it lets you know I was a great inventor. I can do something. I can achieve something. I can be great one day. And so it's important to know what things have been done prior to you so that you can do them too. I think what's also a bigger kind of consideration that we've talked about here is really precedent, right? I think Kale mentioned that, there's no precedent for things. And when you don't have precedents for decisions, you don't know what's going to happen. You don't know those outcomes. Whereas if we know in history what happens when you take people's rights, when you know what happens when people are disenfranchised, then you can begin to understand we don't want that to happen again. I'll just cite George Floyd. So a lot of people watched the George Floyd killing and the aftermath, the protests, the rioting, and it was a big deal. And I will say that it was a big deal, but this was nothing new. But because of the failure of education, because of the failure of knowledge and history, so many people did not know that this was the way that change happened in the past. We can cite back to as early or close as Rodney King to as far back as the Civil Rights Movement. And so it's so important to know these things so that you can see this was not a group of disgruntled people or disgruntled Black people just, running amok, or people who were, in their homes because we were in a pandemic and just wanted to get out and do anything. That wasn't the case. It was people who were educated and knowledgeable about the fact that in order to get things done, sometimes you have to create chaos. Sometimes you have to make people uncomfortable. And so when you have that knowledge, that information, it allows your mind to be shaped and honestly to be able to appreciate or understand certain truths that maybe you don't understand without that information. The other thing I'll just say is that I think that unfortunately, but realistically, a lot of things, systems, money were built on the backs of people who did not receive any of those things. And oftentimes it is very difficult for people to accept that. And I get it. Like when we make mistakes, we don't really want to accept it. Sometimes we do because we feel like, maybe we can correct that wrong. But I think that there's a lot of people who are unwilling to accept what has happened. And some of that has to do with, too, the fact that there hasn't been any true righting of that wrong as well. Ultimately, though, I think, again, going back to what I said before, knowledge being power, if you have knowledge and you have information, it allows you to do better. And so we have to be in a place where we can say, this happened, and so this is what we need to do better.
I appreciate that, Brittany. And I'm just going to share my screen 1 second, and I'm going to ask Raymond to just comment on this. This is the holding in People versus Hall, what I was just talking about. where they found, this was the California Supreme Court, this wasn't Mississippi or Alabama or any states that people normally think about these types of issues. It was here in California, and they held that the words Indian, Negro, Black, and white are generic terms designating race, that therefore Chinese and all people, all other people not white, are included in the prohibition from being witnesses against whites. And they use this holding to let the murderer of an Asian man go free, even though dozens of Asian people witnessed this brutal murder. And Raymond, I just want to get your thoughts. Why should we want people to know that this happened? Why shouldn't we sweep it under the rug and pretend that everything has always been beautiful and wonderful? Why is it important for people to know that this is a part of our history?
Sure. So as we sit here today, Black, brown, and queer people in America are being killed or are dying in disproportionate rates. And this is happening precisely because of the centuries of racism and oppression that has been institutionalized in our country, like such as decisions like what you just described, right? And these efforts to take away critical race theory education, I mean, it serves only to erase all of the experiences and suffering and histories and legacies and contributions of immigrant communities and communities of color really to our country's fabric, right? And at its core, it sanctions assimilation into white supremacist culture and discourages communities of color from celebrating their cultural identities wherever they are, right? And, you know, psychologically, it imparts to people of color that they are lesser than their white counterparts. And if you have laws that encourage that, I mean, the impact on future generations is gonna be immense, right? For our children and for our children's children to hear that there's only one version of history and that their version of history wasn't worthy enough to be shared. I mean, there is no greater disservice than that to give to our children. I just want to raise again, like, I think all of these cases that we're talking about, they're all interconnected, right? It's all an effort, a concerted and strong effort by the right to basically pull back our rights as human beings in 2022 and beyond, right? And so again, I just want to impress, you know, the importance of, like, we all need to coalesce, right? Like, people who really care about these issues, like, we all need to coalesce together. The Supreme Court decisions, yes, they're very depressing to be candid, right? And the trajectory of the Supreme Court is very depressing, but it just underscores to me the importance of being creative about how we can figure out solutions that exist outside of the law, of jurisprudence, right? And really calling people from other states and doing phone banks, telling people how important it is to use the electoral process, the election process, to make a change when our Supreme Court justices are failing us, right? So that's a long-winded response, but it's, you know, whitewashing of culture should not be happening, and it shouldn't be happening in 2022. And so we can't let that happen for us and for our children.
Thank you, Raymond. And that's a perfect segue into the next topic, which is Moore versus Harper. I think this is probably the most important civil rights case in American history, and I don't think that's overstated. It's the most important case as it relates to our democracy in American history, and it involves the independent state legislature theory, and I'm going to give Rafael an opportunity to comment on this, but just to summarize briefly, depending on how the US Supreme Court rules on this case, it could empower state legislatures to decide how to administer their electoral votes completely without any respect for the popular vote in their state in federal elections. So for example, if you have the great state of Georgia goes for a Democrat based on the popular vote, if the Georgia legislature is controlled by a different party, they can decide, hey, we don't like that the popular vote went for this guy. We're going to give our electoral votes to someone else. So essentially, it would give state legislatures the power to nullify the popular vote in their state and give the electoral votes to whoever they want. So our elections wouldn't matter. Votes wouldn't matter. People in power would be able to stay in power forever. It's extremely dangerous. And if this is decided in favor of these legislators from North Carolina in a way that it would nullify the vote, we're in big trouble. And Rafael, I know you had some thoughts on this that you alluded to. I want to give you a chance to speak on this.
Well, I think you've summarized everything that's at stake very well. The critical issue then becomes, how do we continue to fight the good fight if in fact it's possible for the Republican-controlled state legislatures, of which the majority of the states are Republican-controlled, are able to take this additional power granted by the Supreme Court and consolidate it into the ability to decide elections. We're talking about actually deciding the 2024 election regardless of the popular vote, regardless, in fact, of the electoral college vote that one would assume would be resulting from the vote in that state. So this, to me, and I'm mindful of the fact that we only have another 8 minutes, points to the fact that those of us who are lawyers need to be doing everything we can to encourage people to work within the legal system. We need to continue challenging all of these laws. We need to continue bringing these court cases, but we also need to look to the actions of our forefathers. I think and others and parents. I think that the history there is absolutely critical. During the AIDS crisis, it was all about raising media attention. Before that, it was about popular action. It was about disruption. It was about protesting. It was about exercising those rights that are afforded to us in the Bill of Rights, that are, even by the most conservative definition, ingrained in this country's background, and taking those and really making use of them.
Well said. I will briefly just summarize Florida. We have it on our outline as Florida, 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 and then we'll get some final thoughts because I do see that we're running out of time. So Florida really touches on a number of these different issues that we talked about. There is the infamous Don't Say Gay law, which has been interpreted by a number of school districts in Florida to prevent LGBTQ teachers from talking about their same-sex partners, even having pictures of their same-sex spouses, partners on their desks, or having anything that looks pro-LGBT. That also requires teachers and administrators who learn that there is a student to be LGBTQ or LGBTQ student comes out to their teacher or administrator and notify all of the parents in the school that there's an LGBTQ student here in the school, which is outrageous and could lead to an increase in suicide. Gerrymandering, which has happened in Florida, it's happened in Texas, it's happened all over, that has eliminated Black representation, and substantially reduced Hispanic representation and Asian representation. Texas is another example. So in Florida, they have completely eliminated all the majority Black congressional districts, and that has been upheld by the Florida Supreme Court. In Texas, for example, you have almost an equal population as it relates to white and Hispanic. I think it's roughly about 38% or so. The white population was increased in congressional districts from 22 to 23. The Hispanic population was reduced from 11 to 10. the Black population, which is pretty large in Texas, I think it's close to what, 15% or so, completely eliminated as far as representation. And the Asian population there, also their representation non-existent. So we have all these voting rights issues, and we're going to have another forum to get into all of these things here. And then finally, the law that they have that limits diversity, equity, and inclusion instruction in Florida is also extended to private businesses. So any private business with 15 or more employees is prohibited from having diversity, equity, and inclusion instruction. So some of the most restrictive laws we see coming out of Florida, it's something to pay attention to. They're also banning gender affirming treatments, even for adults, having a 24-hour waiting period. The Medical Association completely banning it for young people. So many different things. We're going to have another talk. So I want to give folks an opportunity. I don't want it to be all doom and gloom, to talk about some things that they believe that we can do or should do to try to protect our democracy and protect civil rights. And I'm going to start with you, Brittany, because I could see that you had something to say before I did the quick Florida summary.
Thank you. So I'll just comment briefly as to what I was going to say before. I think that what we all should almost always look at or look to is what preceded an action, what preceded a change. And so the real basis for the changes in terms of the electoral votes was how the presidential elections have been won in the last few elections. Also, we all know about the big deal with Georgia. And, those are the things that are trying to be changed. And so when you look at it and you see what's the real issue, that is telling to tell you that there's a problem. But what I'll say just to close us out is I think that we all need to continue the conversation, right? And so that's why this is so important to talk about it, to get like-minded people to understand the issues. I hope that there were some people on here who were enlightened. It wasn't just a group of all the same like-minded people. And then the second thing I think we need to do is we need to take those stands. It's easy to have the discussion, but then when something is brought to your forefront, you do nothing. So I think we have to take the opportunities to take a stand. And then last thing I think is we ourselves need to do an inward look and see what are we doing to help or hurt the cause. I'll use an example, and his name is slipping me right now, but Serena Williams' husband, he was the CEO, I believe, of Reddit. And after what happened in 2020, he literally said, I'm going to step down because I want to give my space or my spot to a person of color. And he looked to his daughter, who happens to be a person of color. He looked to his wife, who happens to be a person of color. And he has an intimate connection with that reality. And so I think that we have to really look introspectively and see what are we doing or what can we do individually that may have a huge impact. That was one position for him, but it got national attention. So many people see it, and I'm sure others are moved by it. So thank you.
And Kel, we'll go next to you, and we'll give everybody a final thought, even if we go over 5 minutes or so. Kel, what is your thoughts about what we can do or what we should be doing?
Yeah, so I want to pull in some things that people have said, and also sort of answer one of the questions that popped up in the chat, which was basically, how do we get people to understand that originalism does not serve us? And something I want to highlight, and that I think it's really easy for lawyers to forget, is we get so caught up in the legal arguments and where this comes from that we sometimes overlook that most of middle America, as the question asker phrased it, is not really getting into the constitutional theory at play. For a lot of people who are in a position to push for change, ask for change, the general population that can be involved in change, they don't always get the nuts and bolts of what's happening the way we do as attorneys, and they don't need to. What they need to care about and understand is sort of the high level systems at play, and to care about these things and to be invested in them. something that has been, Rafael brought up and that I think is very important right now, is when we talking about it, part of what's happening there is making people familiar with things that they might not be familiar with. There is a remarkable ability by the right to weaponize what people don't know against them and against us. And a lot of people react to, to tie it back to Brittany's point, when we look at a step forward in civil rights law, what we often see is an immediate backlash. So we got a Bergefell, right? And then all of a sudden we started attacking a trans people left and right, not that far down the road in terms of history. And so for a lot of people, while these feel like discrete issues, we can actually start to see the patterns that emerge, how these things are tied together, and we can address that in more meaningful ways. But that backlash, I would say, a lot of times, and not exclusively, but a lot of times, is rooted in fear. People don't like change. They don't like feeling like their values are being threatened. They don't like feeling like the way of life that they know has been threatened. I'm not telling everyone ever to go out and like talk to their neighbor who is a bigot. Like that's a little bit extreme. But I know that like I come from a fairly conservative family and we're all white, right? Like I'm a first generation American and I'm much more visibly loudly queer than a lot of people in my family. And I'm much more left than a lot of people in my family, but I still have a responsibility in my understanding to go back to my community, that part of my community, not just the community I've built out here, because that feels, not safe in all the ways, but is safe enough for me to have these conversations with them, even if they don't get it or understand me. And I will say that like, I have watched my family change on certain issues over the years. There are a lot of reasons that people might not feel able to do that with their families of origins or their community of origin. And so, like I said, this is not me encouraging everyone to just like go put themselves in a position where it could be harmful. But I do think that remembering that the people that we don't agree with, often are not coming from the place that we think they are. And maybe there's a little bit more opportunity for movement really matters. And a lot of successful legal movements have required a shift in public opinion before the legal action can take place. And so what we see in courts is if people are leaning one way or another, then the courts will sort of start to adapt to that. So it's not perfect. It's not the only way to do things. And as we're seeing in decisions right now, public opinion and certain perspectives on things that may be popular don't necessarily change every judicial decision, right? And this is not an overnight fix. But the reason that we have activism that includes public awareness campaigns and disruption and media pushes and things like that is because we're trying to control the narrative. And so I'd really encourage people to plug into that as much as they can, to remember that the only opportunity to get involved does not operate on the state or national level, but in fact operates on the local level as well. And for lawyers, I would specifically say, make sure you're looking at people on the ground who are already doing this work. There are a lot of organizations already in these spaces who are connected to activists, who are connected to these communities, who actually understand what those groups need. And we as a profession have an occasionally obnoxious tendency to come in and be like, oh, don't worry, the lawyers are here, we're going to fix it. And move lawyers very much operate from a place that's like, no, like I'm a tool. I'm a one tool we can use. I am not the expert and I can't just do this my way or the highway. And I think that I would really encourage any lawyer getting involved in social justice issues to think that way. Think about co-counseling, think about when you can plug in on amicus briefs, anything like that. The people on the ground doing this work, whether they're lawyers or non-lawyers, are exhausted right now and feeling overwhelmed, and manpower and the resources and the fresh energy that we can bring to these spaces is so needed, as we push through to whatever comes ahead.
Thank you so much, Cal. And that's a perfect segue to Chris. You're in the trenches. What are your final thoughts about what we can and should be doing? And you're already doing a lot of that great work.
I think, what we're really talking about at the end of the day is who has power in this country to determine the future of the people who live here. And the conservatives, in many ways, are really consolidating power in the judiciary, clearly, but their legal movement is very closely tied to other movements that are also consolidating power: electoral power, philanthropic power, cultural power. So I guess I would just invite the other side to think about how, especially us as lawyers, can work in sync with other movements in order to achieve these outcomes where we, bring our vision of America that is fair to everyone, to bear, to reality. I just wanted to say this really quickly about critical race theory, because I studied critical race theory, kind of saved my life in law school, and I wouldn't be here were it not for critical race theory classes and the professors I had. That what's happening is an absolute distortion of what critical race theory is, but it is part of this cultural project they have to assert, the way things should be, for groups that are rapidly becoming the numerical majority in the country. So I just want to say one more thing about the legal movement in particular, because that's something where we all are. We need to really think about the long game. How we got here today was the result of a project that started 20 and 30 and 40 years ago. And I guess I just have a little bit of dissatisfaction about how organized our side is at bringing, the pendulum back to our side. It is about unity, but I think we as lawyers need to get it together a little more. So I invite the conversation to continue, and just want to say thanks again for holding the space.
Thanks so much, Chris. And Raymond, we're going to get your thoughts. And I'm just going to say quickly as to what Chris said, we can't always be in reaction mode, right? We have to be planning ahead and thinking to the future. Raymond, your final thoughts about what we should and can do. Oh, you're on mute.
Sorry, I'll keep it brief. Just two things. The first is really the importance and value now more than ever of coalition building. I think people have touched on that and kind of reaching across sectors to be able to generate the change that we want to see, and really shifting the movement from beyond having discussions to action, right? Because we can have all the discussions that we would like and keep these rights at a theoretical level and academic level, but I think the next step really is to put it into action and in an organized way that is effective and strong and will get us to the place where we want to be. The second is just a reminder that, to those of us who are lawyers in this chat, or those in the legal profession, that we have so much power and ability to create change on behalf of our clients and on behalf of people impacted by what we've just discussed today. And so just not to lose sight of that ability and that privilege to be able to do that for other people. Finally, is just keep the hope alive. I know it might seem like dark days are ahead, but keep the hope alive and take care of yourselves and take care of each other, so that when the time is right, we're able to fully show up for our communities and the communities that we represent, and for the communities, all communities that are impacted by what's going on right now. Thanks. And thank you again, Terrance.
No, thanks, Raymond. Beautifully said. I agree with everything that you said there. And before Rafael comments, I just want to say for the comment that we had in the chat, what about middle America? I think Kansas is a perfect example. A few days ago, they were able to preserve choice in one of the reddest states in the union. It can be done. Rafael, your thoughts about what we can and should be doing?
I think everyone has captured exactly what we need to be doing. Stay together, stay strong, and keep fighting through all the mechanisms people have identified.
Thank you, Rafael, and thank you everybody for joining us. We appreciate it. We'll have to do this again. There was so much information in a short period of time, but this panel was just absolutely amazing. Thank you so much. It was recorded. It'll be posted. Have a wonderful evening, and we look forward to seeing you really soon. Have a great one, everybody. We appreciate you. Have a good night.